A shareholder agreement is the legal document that outlines the relationship and obligations between shareholders of a company. Now, this agreement typically covers issues such as how the company will be managed, the responsibilities and rights of each shareholder, and the transfer of shares, and of course the distribution of profits. Now, if there are two or more of you as shareholders, you need a shareholders agreement. I cannot stress this enough. I've seen so many arguments and problems between shareholders that could have easily been prevented by a written shareholder agreement. In this video, I will outline what a shareholder agreement is and what should be in it at a bare minimum. Now, a shareholder agreement is a legally binding contract that outlines the rights and responsibilities of the shareholders in a company. It is typically used in closely held companies where there are only a few shareholders, or in cases where shareholders want to clarify their rights and responsibilities beyond what is outlined in the company's bylaws or articles of incorporation. The contents of a shareholder agreement, well, that can vary depending on the company and the specific needs of the shareholders. A shareholder agreement is not always necessary, but it can be a valuable tool for protecting the interests of shareholders and ensuring the smooth operation of the company. Now, some of the benefits of having a shareholder agreement, well, they include the shareholder rights and responsibilities. Now, this section defines the rights and obligations of each shareholder, including their voting rights, obligations to contribute capital, and any restriction on the sale or transfer of their shares, reducing the likelihood of any misunderstanding or disputes between partners. Now, a shareholder agreement provides protection for minority shareholders by ensuring they have a say in important decisions and preventing them from being, well, squeezed out by majority shareholders. By clearly defining these rights and obligations, shareholder agreements can help to avoid misunderstandings or disputes between shareholders. Management and control. Now, this section outlines decision-making processes for the company and the powers and duties of the board of directors and the company officers. Now, this can include things like the composition and responsibility of the board of directors, the appointment and removal of officers, and the decision-making process for important company decisions. By establishing clear procedures for all decision-making, management and shareholder agreements can help ensure the smooth operation of the company. Profit distribution. Now, this section determines how the profits of the company will be distributed amongst the shareholders. Now, this can include percentage of profits that will be distributed to each shareholder and the process for making those distributions. By outlining these procedures in advance, shareholders' agreements can help to avoid disputes over profit and its distribution. Dispute resolution. Now, this section outlines procedures for resolving disputes between shareholders in the company. Now, this can include procedures for mediation, arbitration, litigation, as well as provisions for the buyout of shares in the event of a dispute. By providing clear procedures for dispute resolution, shareholder agreements can help reduce the likelihood of costly and time-consuming litigation. Protecting the company, the business's interests. Now, a shareholders agreement can include provisions that protect the company's interests. Now, this can include non-compete clauses, confidentiality clauses, or provisions to prevent shareholders from taking actions that could actually harm the company. Now, by including these provisions in a shareholder agreement, the company can ensure that its interests are protected as well as it can be. Exit strategies. This section outlines the procedures for buying and selling shares and the process for the dissolution of the company. Now, no one likes to think about the end of the company, but it's important to have a plan in place for what will happen if the business needs to be liquidated or sold. The agreement should outline the circumstances under which the business can be sold, what triggers a sale, how the business will be valued, as well as how assets and liabilities will be divided in the event of a sale. Now, if you are considering starting a business or becoming a shareholder in an existing company, seek advice from a lawyer well versed in these matters to discuss whether a shareholder agreement is appropriate for your own situation. Now, a business will also need a business plan that, all shareholders can agree on. But how do you write this plan? Check out this video. I'll see you over there. Thanks for watching. See you again. Cheerio.